Now, Your Honors, my second point concerns precisely what Justice Delahunty was drawing the distinction of between the situation of abortion and the situation of contraception. And that is this. If it were the case constitutionally that the unborn child or human fetus was a person, then that person would have full constitutional rights, and then that would present much, much different issues. The problem is that this law, the law generally, and our Constitution and traditions have never recognized the unborn, the preborn, the fetus as persons in a legal sense. Now,
let me ask you about that. I've seen state laws, and we've reviewed state laws that address murder of a pregnant woman as being a double murder. Many states have estate planning laws that talk about the unborn issue of someone at the time of their death as being an heir. So if we can create legal rights for unborn people in those settings, why don't they have legal rights in this setting?
That's an excellent question, Your Honor. And I would draw a sharp distinction between the law's ability to treat the unborn as legal entities for certain purposes and the idea that they are persons vested with constitutional rights within the meaning of the Constitution. The law is unclear in its general treatment of the unborn. For some purposes, the unborn are treated as, if you violate their rights or injure them in some way, there is a legal remedy. But that is a long way from saying that they are constitutionally a person. Essentially, the criminal law, the tort law, the law of inheritance sometimes recognizes the unborn as possessing certain legal interests that the state will protect. That does not mean that the unborn are legal persons in the constitutional sense.
But counsel, if this court considers General Electric Corporation to be a person, which it does, how can it not consider an unborn child within 2 hours of delivery to be a person?
Well, Your Honor, I will not debate whether corporations should be treated as persons. That's an interesting issue. It's not the issue presented in this case. The issue that would be presented is if the unborn were persons, would you then be incumbent to do some sort of balancing of the constitutional rights of that person versus the other person?
But that's what we did in Roe versus Wade implicitly with the trimester test.
Exactly, Your Honor. To the extent that this court recognized that the unborn were at least potential human life, right? That they have the potential to become born human beings with constitutional rights. This court sought to strike a balance in which the rights of the unborn child or the interests could be protected by state law. And that is the regime that, Your Honors, we seek fundamentally to uphold. Before the fetus could live outside the woman's womb, the law has never treated it as a person in the whole sense. Up to the point of viability, then, as this court held in Roe versus Wade, the right to abortion must be the unrestricted choice of the woman and in consultation with her doctor.
But I'm troubled by the reliance on viability because birth could be as arbitrary as 6 months or as 6 months post-birth or 89 and a half. Maybe we should consider viability in the context of all stages of human life if we're going to use viability. And I'm really troubled about viability as the test for constitutional rights.
Your Honor, I appreciate that concern. The difficulty is with drawing the line any place. The line that the law has traditionally drawn most clearly for purposes of constitutional status is the line of birth. In fact, you can look at the various situations in which the Constitution uses the word person in other contexts. Each time the Constitution refers to persons, it means a born person. Persons born or naturalized in the United States. Indeed, under the Census Clause, when we count persons, which is what the Constitution says to do, we count live persons. We've never counted the unborn as persons within the meaning of the constitutional term.
But counsel, in 1792, we didn't have ultrasounds.
This is
we
true.
talked about quickening, right? So we can't really go back to what their medical knowledge was as some guide to what the personhood is in 2013, can we?
Well, when we're considering the meaning of a constitutional term, we would be considering the meaning that that term had at the time that the persons who wrote the Constitution or the constitutional amendment were writing. What would the term been understood to mean? If you look back to the earlier years of the Constitution, and this has been carried forward, persons were not understood as full constitutional legal persons until the point of birth. There might be interests that we would protect in potential life, but this is why it has to be a balancing test, and this is why the court struck the balance in favor of the choice of the woman, the decision of the woman. I keep coming back to that freedom of privacy with respect to medical decisions up to the point of viability. And even past the point of viability, this court struck the balance saying, at that point, the state could have an interest in protecting fetal life, the potential human life. However, that interest must always, in the point of pregnancy, yield to considerations of the woman's health broadly conceived. We think that is the appropriate balance. In fact, as Your Honors indicated in your questioning to Attorney Collette, the logic of the opposing position that said that the unborn human fetus is a constitutional person would push the line back all the way the other way on the slippery slope. It would say that the fertilized egg, the zygote, is a constitutional person, and that most forms of assisted reproductive technology that involve sometimes implantation of embryos or discarding of embryos, that's mass murder prohibited by the Constitution. That, with all due respect, that position is simply absurd. It is simply...
Counsel, can the right of a living human to the protections of the state really depend on viability alone? An 80-year-old woman on life support in a hospital is not viable. She is dependent on medical technology. Does she therefore have no right, no constitutional right to protections from being murdered?
The line we draw, Your Honor, is between persons who have been born and persons who have not yet been born. There are many difficult issues surrounding end-of-life decisions, and this court's cases have addressed privacy rights and autonomy rights with respect to end-of-life medical care decisions. But the 89-and-a-half-year-old is clearly a constitutional person
But don't
in a
our
way that the
decisions about the start of life have a direct bearing on our decisions about the end of life and vice versa?
Of course, Your Honor, I think they have a bearing and there's a connection and relevance, but they are distinct decisions. That's our short point, is that the unborn have never been treated as persons in the constitutional sense entirely by the law. That has not been this court's approach, and for 40 years, that has been a holding of this court.